Hi everyone. In this session today, I will be discussing the four cardinal principles of law of evidence. And these four cardinal principles are important for your preliminary examination and mains examination of your Judicial Services exam. In my previous two videos, I have already discussed the scheme of the Indian Evidence Act. And in the second video, I have given a detail regarding what is a fact, fact in issue, and a relevant fact. So, in this hour of today, I will be going in detail regarding the four cardinal principles of law of evidence. So, before I begin with the session, I want all of you to go and quickly grab your Bare Act, a notebook, and a pen and take a lot of notes in this session. So, the cardinal principles of law of evidence. First is the oral evidence excluded by the documentary evidence. Documentary evidence. The first cardinal principle of law of evidence states that कि अगर एक document है, in that case हम oral evidence को exclude करेंगे. In case a fact can be proved by a document, we are going to exclude the oral evidence. So the principle has been discussed under section 59 of your Indian Evidence Act, along with section 91, read with section 144 of your Indian Evidence Act, and also section 92 and 99 of your Indian Evidence Act. So ये जो first cardinal principle है, ये आपको section 59 Indian Evidence Act में दिया गया है. Along with it, we also have other provisions which are talking specifically about documents. That is section 91 read with section 144 of the Indian Evidence Act and section 92 and 99 of the Indian Evidence Act. In today's session, I will be discussing in detail regarding the oral evidence which is given under section 59. And in my next session, I will be interlinking section 91 with section 144, and also I will be talking in detail regarding what is a documentary evidence. Second cardinal principle of law of evidence is exclusion of hearsay evidence. Exclusion of hearsay evidence. So, what is a hearsay evidence? जो आपने खुद से देखा नहीं है, खुद से सुना नहीं है, मतलब जो सुनी सुनाई बातें आपने खुद से उस चीज को महसूस नहीं किया है, उसको हम कहते हैं hearsay evidence. So, as per law of evidence, only direct evidence is appreciated and hearsay evidence is excluded. हम hearsay evidence को exclude करते हैं. Hearsay evidence होता क्या है, हम उसको exclude करते हैं. That is this principle. Now this principle is covered under section 60 of your Indian Evidence Act. Section 60 of your Indian Evidence Act. So we always take the direct evidence and we exclude the hearsay evidence. That's the second cardinal principle of law of evidence. Coming on to the third principle, exclusion of secondary evidence by primary evidence. सो जो हमारा थर्ड प्रिंसिपल है वो कहता है कि अगर हमारे पास ओरिजिनल डॉक्यूमेंट है, इन दैट केस we will exclude the photocopy. That means we are going to exclude the secondary evidence in case we have the primary evidence. Primary evidence क्या होता है? Primary evidence होता है the document itself. So if you have the document itself, we are going to prove the document by getting that document in the court instead of getting a certified copy or a photocopy. So that is excluded. So what is a secondary evidence and in what circumstances do we allow the secondary evidence? And ये जो पूरा का पूरा principle है that we are going to exclude the secondary evidence in case we have the primary evidence is covered from section 61 to 66 of your Indian Evidence Act and also section 162 to 164 Indian Evidence Act. So ये जो sections हैं ये बात करते हैं third principle की, that is exclusion of secondary evidence by the primary evidence. And the fourth cardinal principle of law of evidence is special powers of the court. कोर्ट के पास कुछ स्पेशल पावर्स है to check the reliability and to ensure that the justice is not only mechanically done but it is actually done, and to check the fairness and reasonableness in a particular proceeding. So we have section 165 Indian Evidence Act, which is the court has the power to examine any witness, to call any witness, to ask any question from that particular witness. And similar section we also see under CRPC, under section 311 and 313 CRPC. अगर प्री में पूछा जाता है कि कोर्ट विटनेस का सेक्शन कहाँ है CRPC में, सो कोर्ट विटनेस का जो सेक्शन है वो है सेक्शन 311 CRPC. And we also have provisions under your CPC, that is Order 16, Rule 14, and we have Order 18, Rule 17, CPC, which talks about the power of the court to ensure reasonableness, fairness, and therefore the court has the power to ask any question from any witness or any other person which court wishes to examine. He may not be in the list of witnesses, but court has the power under these provisions to call any person and to examine. So these are the special powers of the court just to ensure the reasonableness and fairness while doing justice. So these are the four cardinal principles: oral evidence excluded by the documentary evidence, exclusion of hearsay evidence, exclusion of secondary evidence by primary evidence, and the special powers of the court. Today I will be talking about the oral evidence. Oral evidence. Now, oral evidence is defined under section 59 of your Indian Evidence Act. So if you have your Bare Act, please kindly go to section 59 of your Indian Evidence Act, and it is covered under chapter 4, that is oral evidence, and section 59 states proof of facts. That means when you have to prove a fact, how? By oral evidence. So how do you prove a fact by oral evidence? All facts, jitne bhi facts hain. Now I'm going to leave comma to comma. So when I'm saying I'm going to leave comma to comma, sometimes we adopt this strategy to understand the provision. Sometimes we see that there are certain provisions which are too lengthy and we find it difficult to read and understand that provision. उन cases में आप comma to comma छोड़ सकते हैं, and if you then read the sentence, it will make sense. Like for example, in this case, in this provision, we have all facts and then we have a comma. So I'm going to leave comma के बाद जो statement है, जो line है, मैं वो छोड़ दूंगी और मैं आगे आप देखेंगे records के बाद फिर से comma है. तो मैं उतना part छोड़कर आगे से पढ़ूंगी. All facts may be proved by oral evidence. So that's the general rule. Section 59 ने हमें क्या principle दिया है कि जितने भी facts हैं, they may be proved by oral evidence. Except, now if I read comma to comma, that's an exception. Except the contents of a document or electronic records. That means that the contents of the document or the electronic records will not be proved by oral evidence. Apart from that, everything else can be proved by oral evidence. Let's understand section 59 in detail now. So section 59 कहता है that all facts may be proved by oral evidence. Now, what's an oral evidence? Oral evidence कौन देता है? Witnesses आके oral evidence देते हैं. अभी हम इस पर भी बात करेंगे. अभी हम section 59 को पहले एक बारी डिटेल में समझ लें. Now it says, except in two cases where you cannot prove it by oral evidence, that is, in case of a document and in case of electronic records. So in case of a document, you're going to prove it by the document itself. You're going to prove it by the document itself. You're not going to give the oral evidence. And in case of electronic records also, you're going to prove it by the electronic record itself. So आप document और electronic records को oral evidence से prove नहीं करेंगे. उसके अलावा जितने भी facts हैं आप उनको oral evidence से prove कर सकते हैं. So now we have to understand कि ये जो oral evidence है ये कौन दे सकता है, कौन है ये oral evidence जो कोर्ट में आके depose कर सकता है. Oral evidence is given by the witness. So now when this witness comes to the court and gives the evidence, the court will not presume perjury. Now what is perjury? Perjury क्या होता है? Perjury is when you give a false statement on oath. Perjury means giving false statement on oath. It is defined under section 191 IPC. 191 IPC states that if a person is making a false statement on oath, he is liable for the offense of perjury, and the punishment is given under section 193 IPC, which is 7 years in case you make a false statement in judicial proceedings. अगर आप कोर्ट में आके कोई false statement देते हैं and that too on oath, in that case the punishment would be 7 years. So now when the witness comes to the court and gives the oral evidence, court will never presume perjury. But before acting upon the oral evidence of a witness, the court must satisfy itself about the credibility. So there are two ways to establish the credibility of a witness. That is intrinsically or extrinsically. So when I'm saying extrinsically, the court, I mean to say that court will see and examine that whatever testimony, whatever evidence that the witness is deposing in the court is in line with the other proved circumstantial evidences. So witness जो भी कोर्ट में आके oral evidence दे रहा है वो corroborate कर रहा है, वो support कर रहा है with other proved circumstantial evidences. Now intrinsically the court will examine and check the veracity of a witness by cross-examining. Under section 165 of the Indian Evidence Act, court can ask him question and check his veracity by cross-examining. So here court will cross-examine him to check the veracity and ask questions under 165 Indian Evidence Act. And here court will examine that whatever evidence that the witness has deposed in the court is in line with other proved circumstantial evidences. So in case the oral evidence given by the witness stands the test of cross-examination and also it positively fits into the scheme of the proved circumstantial evidences, and thirdly, it is consistent within itself. In that case, the oral evidence of the witness shall not be disregarded. There is this very famous Latin maxim that is falsus in uno, falsus in omnibus. False is one thing, false is everything. False is one thing and false is everything. This maxim is applicable in England, but it is not applicable in India. India में ये applicable नहीं है. As it has been rightly stated by the Honorable Supreme Court in the case of Nisar Ali versus State of UP in the year State of UP 1957 Supreme Court कि ये जो maxim है falsus in uno, falsus in omnibus is not applicable in India. Why? Because in case the witness comes to the court and gives the oral evidence, which is almost everything is true, but there are few statements which are false. In that case, we are not going to disregard his testimony just because he has given few statements which are false. इंग्लैंड में ये मानना है कि अगर कोई विटनेस कोर्ट में आके ओरल एविडेंस देता है और अगर उस विटनेस ने कुछ भी चीज फॉल्स बोली है, उस केस में हम उस विटनेस की पूरा का पूरा टेस्टिमनी को डिसरिगार्ड कर देंगे. In India, it is the duty of the court to separate the truth from the falsehood. And in this case, Nisar Ali versus State of UP, 1957 Supreme Court, the Honorable Court has also stated that if the false part of the testimony is not separable from the part which is the true part, in that case, the entire testimony will be disregarded. But in case the false part can be separated from the truth part, उस केस में हम उसको separate करेंगे because it is the duty of the court to sift the grain from its chaff. So the truth part will be taken in evidence and the falsehood will be disregarded. ये जो maxim है ये आपके या तो preliminary examination में आपको इसका मीनिंग पूछा जाता है इस लैटिन मैक्सिम का, या मेंस में एक शॉर्ट नोट के तरीके से भी आपको इसका क्वेश्चन पूछा जाता है. सो आई होप सेक्शन 59 इज एब्सोल्युटली क्लियर दैट इन केस you want to prove a fact, you must prove it by oral evidence. And before taking the oral evidence of a witness, you must check and establish the credibility of a witness by either cross-examining or also by looking into the evidence that is being deposed by the witness, that whether it is corroborating and supporting with the other proved circumstantial evidences. In that case, the oral evidence of the witness will not be disregarded in case it stands the test of cross examination if it is fitting well into the scheme of other proved circumstantial evidences and it is consistent with itself. उस केस में हम उस विटनेस का ओरल एविडेंस को डिसरिगार्ड नहीं करेंगे. एंड ये जो मैक्सिम है falsus in uno, falsus in omnibus, it is applicable in England and not applicable in India. In my next session, I will be discussing what is a document, and we are going to take forward this first cardinal principle only, that oral evidence is excluded by documentary evidence. नेक्स्ट सेशन में मैं डॉक्यूमेंट्री एविडेंस के बारे में डिटेल में हम लोग डिस्कस करेंगे. इफ यू फाइंड दिस वीडियो टू बी इंफॉर्मेटिव एंड वैल्यूएबल, do not forget to subscribe, like and share. Thank you.